All right, here we go. Tuesday morning, we have Mark Violet with us today.
Good morning.
He is an attorney, and he owns a title company. First of all, I hope yesterday was awesome. Super smoking great. Hope tomorrow's even better. But Mark's here today because he wants to talk about acts of God, or force majeure is what we call it in the legal annals of Florida real estate. And I assume, is this a fair assumption that there is some sort of act of God in everywhere, legal-wise?
Well, I guess that depends on your beliefs, but there's going to be a legal provision in most contracts that talk about unforeseen events that allows the buyer or the seller to basically cancel the contract.
Okay, or at least put things on pause, right?
Correct.
So we're going to talk specifically about Florida for a minute because that's what Mark knows. Mm-hmm. And we have a hurricane. Is it in the box?
So
what's in the box?
Right. So today is September 24th. So if you look at the Weather Channel, you'll see that they're alleging tropical storm is going to turn into Hurricane Helene by Wednesday. Today is a Tuesday, so we don't know what the future brings. But
let me go back in time, though, here for a second.
Mm-hmm.
Hurricane, we get that because we live in Florida. Wildfire? Tornado? What are we talking about if you're not here?
So
what do you think?
I think it depends on the geographical location. So, for instance, in Florida, we have two different contracts.
Okay.
We've got the FAR, and then we've got what we call the CRISP. And in there, it helps define which categories will fall into what we call force majeure, which is AKA acts of God or unforeseen events, or if you
doesn't have to be a natural disaster. Government could shut it down.
Correct. Could be a war.
Could be a war.
Could be that you have one bridge that links Blue Water Bay to Destin, and that's the only way to get to an island, and a barge hits the bridge, and now you can't get to closing because of something that nobody contemplated at the time they entered into the contract.
Could be a pandemic.
Yeah. Correct.
So, but today we're going to talk about a hurricane that is blowing around.
Yeah. So, and again, what you were talking about earlier is, and one, you call these pro tips. If you have a closing that's coming up and you know we're in hurricane season, which in Florida is going to be anywhere from January to December. That's a joke. But traditionally,
the 1st to the 31st?
Yeah. Okay, traditionally, good. It's anywhere around June, July, August through the end of November. We even had a hurricane, I think, last year in December. So if you know we're in that time frame and you have the buyer, or even if you represent the seller, you recommend to the buyer, you can bind your insurance, your hazard insurance.
This is the linchpin right here, the insurance, Correct. Right?
Correct. You can bind your insurance as early in the process as you want. And then even if there is a hurricane or tropical storm out in what we call the grid, and I'll explain that in a second, then the closing, if nothing else unforeseen occurs, can still move forward. What happens is most people tend to wait until a day or two before closing. Yes. Then they go to their insurance company.
No expense, all that.
Correct. And maybe that's alleviated itself a little bit in today's world because insurance is so expensive. People are now trying to figure out what are my costs. So it's possible that they're getting quotes, but that doesn't mean they're binding their insurance. So what happens is there is what we call a grid.
Okay, hold on. No insurance, no close.
If there is a named storm within the grid, or a hurricane even in a further grid. So in our area, when we talk about a grid, it's going to go into the Atlantic Ocean. It's going to go south into the Gulf of Mexico or even the Caribbean area. If you can determine where that line is, you're magical. It's going to go up to North Carolina, and it's going to go west almost as far as Texas.
And you can find it because they post this. They call it the box.
Right. And one thing I did learn is not all insurance companies are under the same rules. So even if you call one and they say, I can't bind you because of a certain reason, there are other ones, and I'm surprised that there has not been some sort of national legislation on this to say, nope, the box is the box is the box. But apparently there is some discretion. But in a nutshell, you can pull up a grid on Google, and you can kind of get an eyeball of if a tropical storm makes its way into that grid area. What that means is insurance companies, now their hands are tied until the tropical storm is either dissipated down into what's one below tropical storm?
Depression.
Depression. There you go.
Yeah. Realtors are familiar with depression.
Right.
Anyway, here's something. I'll give you another angle on this. We have a property management aspect of this, and people can buy travel insurance unless there's a storm or something going on. Because think about it this way. Insurance companies are in this thing to make money. They're not going to write policies, when there's a fire next door. Yeah, can I up my fire policy? No.
Correct.
Right? So just be a little bit thoughtful wherever you live or wherever you are. I think even blizzards now are named storms. So I bet even blizzards have something to do with insurance. And
well, Julie's in Arizona, so I'm assuming their contract has a force majeure clause, and then it's going to attempt to outline what they over there would consider the acts of God that spring the provisions.
Locally, yeah.
Ours is basically 10% of the sales price, but we don't have a lot. We have something called a microburst, but they're rare. And they're kind of like mini tornadoes that happen in just small areas, but they just...
unpredictable.
Think of the bottom dropping out of the cloud and just all the force going down. But they're during monsoon season, we have monsoons, but that's just lots of wind.
Okay. So what do we do here? What do? You got to, Destiny's got a closing today.
Tomorrow.
We're fine today. Tomorrow, questionable?
Correct. If the insurance has not been binded. But I think what
about no mortgage? Do we care if it's binded or not? If there's insurance, no mortgage?
So if there's not a lender involved, obviously there's more discretion with the buyer and the seller. If you're a buyer coming in and essentially you have all cash, I'd like to think you're highly intelligent. So you have probably already dealt with the insurance situation. Okay. Although I've been proven wrong several times in the past with cash people, but we'll use that as a presumption. Okay. But so the question would be, what do we do? And the answer is you have to go look at the contracts. So like we were talking earlier, as a realtor, in essence, we'll just say you have two main contracts, even though there's spider webs of versions of the contract, whether it's as is, not as is. You can say you have two main contracts. If you're dealing with maybe a builder contract, who knows what's in there? There may be different terms. So step number one always, and I know buyers and sellers, the first thing they do is they sit down and they read the contract from beginning to end.
I know.
Do you have like a little hit the pun button or anything like that?
Yeah, I have a laugh.
Stand-up comedian.
There we go. Maybe some people don't get my sense of humor. So the first thing really is to read the terms of your contract. Or in my case, most of my agents just pick up the phone like yesterday and said, hey, there's a hurricane. What does that mean? And I always have to say, okay, which contract are we using? Let's go pull it out. Let's read it. And I always get the silence on the other end of the phone, which tells me
they don't know.
They've never even read that sentence
before.
Know which
right. They did in real estate school.
Yeah.
Right. So
they could get 20 wrong on the test and they still pass. And that was one of 20. Sorry.
For purposes of today, we're just going to use the FAR bar as is. What I will tell you is, whether you're using the FAR bar or you're using the CRIS, the language is materially the same. So you're going to get the gist of it. I think the key is to understand, to spot the red flags. Hey, there's a tropical storm. Hey, there's a hurricane. Is it in the grid, out of the grid? Is it coming our way? If so, what do you tell your buyer or what do you tell your seller? If this happens, the contract says, here's what we do. And if this happens, here's what the contract says we do. So in this case, we're looking at lines 61 through 63. That talks about extension of closing date. And why would we need an extension of closing date? Well, because the buyer waited, they didn't bind their insurance, and now their lender is saying, we can't loan you money unless we have guaranteed proof of insurance. You don't have proof of insurance, you can't bind it. Something needs to happen. So it's going to say, in an event constituting, and they use the French term force majeure, which depending on which interpretation you read, either means strongly...
It's French for superior power.
There you go. Superior
John
power. Strong power.
Says that's him.
Yeah. So if it causes services essential for closings to be unavailable, including unavailability of utilities or issuance of hazard, wind, flood, homeowners insurance, closing date shall be. Shall means must. So it's not discretion. Shall be extended as provided. And this contract uses what we call standards. So then it shoots you to what we call standard G, which is at the end of this contract. So understand that
So it's automatic. You don't need an addendum. You don't need anything. This is automatic. There's a storm. There's a fire. There's a thing.
That is correct.
Pushing.
That is correct.
Okay.
And you can imagine the seller who anticipated a closing on Friday.
Yeah. What if he's doing 1031?
Already packed up the house, already moved to the new location, has a simultaneous closing because never contemplated this was going to happen. Do you need to bring that up on every single closing, every listing, probably not. But during the season, you probably need to consider when your seller is going, I need to do a simultaneous closing right now. And you're saying my hands are tied. And then they're blaming you for not saying, well, if this is in the standard contract, how come this wasn't brought up as a possibility that it could occur? And then you have to sit there and go, I don't know. I guess it was my fault.
Yeah.
So be aware. That's why you attend these things. So as you thumb through the contract, there's also, and we'll get to Schedule G here in a second, but there's also other paragraphs that affect whether or not, let's say, storm damage or something occurs.
Yep.
Remember, the buyer has usually the right to do an inspection. And it's going to say that the seller must maintain the property in substantially the same way it was when it went under contract. So let's say a storm does come through, and the only reason the buyer wanted this property was because it had this great palm tree. And now the palm tree is gone. And the buyer says, well,
son of a,
either go buy me a $20,000 palm tree and replace it, or I'm out. So be aware of how these storms can affect. Now, if the seller does go and replace it and creates a substantially the same position it was when they went under contract, then that does not give the buyer an out. Now, they can argue whether the new palm tree matches the old palm tree or whatever, but that's why we have judges and courts.
okay, question.
Mm-hmm.
What if there is damage and you're going to file a policy that requires time? Do we need an extension?
So that is where we get into the risk of loss section. Yeah, so we're going to... You're going to send me all the way to the end of the contract. So what this contract...
This is where everybody forgets to read the end of the contract.
Right.
Mm-hmm.
Well, because you've fallen asleep after the first sentence anyways. So the contracts are normally going to allocate a certain percentage.
Oh, like Julie was saying.
Yeah, so if there's more damage than 125% of the sales price, then the parties can cancel the contract. If it's less than 125%, then the parties could either do one of multiple things. Usually it's they can close the seller. The seller is required to maintain their hazard insurance policy until closing date. And then at closing, basically anything that happens after closing, it's the buyer's insurance. Now, when we do closings in person.
Wait, closing date or
Mhm.
when it closes? Two different things, right? Or is it the same?
Well,
Because you write a contract, we're going to close on this date. What if it gets pushed?
Right. Your closing date is and again, we're going back to contracts because not all contracts say the same language. But for purposes of what we're talking about here, at every closing where a seller attends, this is what I always tell them. I say, you don't cancel your insurance. You don't cancel your utilities. You don't cancel anything until the money is in your bank account.
Mm-hmm.
As soon as you see that, unless you've agreed in writing or agreed with the buyer at some other date, that is the moment you turn your stuff off.
In all cases, really.
Right, because in theory, you still have the risk of loss.
Mm-hmm.
So if you think, well, closing date is on a Friday, and I'm going to cancel on Friday because I'm a penny pincher, and the storm comes through on Saturday, and we haven't funded until Monday because the buyer's lender says you're not authorized to fund or any of those kind of things. So that's why it's important for the seller to understand timing-wise. Now, a separate argument, and we're in a rental community, a whole separate argument, which is not the which is not a purpose of today, but sellers love to think because I haven't got my money until Monday that I'm entitled to rental payments over the weekend, which that may or may not be true depending on the terms of the. Traditionally, the seller's not entitled to those if you don't modify the terms of these.
Okay, I have another question.
Uh-huh.
This one's probably for Andrew, Mark, maybe even Julie, all y'all. So here's the way I operate. I tell everybody everything 100%, make sure they understand it completely before I move on. But a lot of people don't. I know most salespeople just sign the thing. Well, we'll deal with it later, right? If there's a question, we'll just sign it and get me out of here, right? How much do you guys want to explain all this stuff when there's no storm? It's easy when there's a storm.
Right.
But how much you start, there's a possibility of a storm. What?
Well, the problem is, though, the storms. So you normally sign a contract 30 to 45 days before closing.
Yeah.
So, I mean, in August to November, there's always something brewing out there.
You don't want, I mean, I don't want to say, there's a possibility the whole thing could fall down in an earthquake. What? Or a fire could burn this thing down. What? And you start thinking about it. As a salesperson, I'm not going down every conceivable nightmare that could happen.
Right.
But from an attorney standpoint, you're right. Well, you didn't tell me.
Your easy out is to say, I'm not an attorney. Technically, I'm not supposed to explain this to you. If you want explanations, go hire an attorney to explain every single. However, I'm going to, and then you can fill in the blank with whatever you feel comfortable.
I'll give you a general.
Right.
You guys good with that? Andrew, Mark, what are we saying on this?
I think you're exactly right as far as preparing them for the worst. I've had a client die the day before closing, had a house struck by lightning before, of course, a ton of flooding and Harvey. And I think if you prepare them for the worst, it's easy when something minor comes along.
Yeah.
You don't have to
I'll
show-
argue the other side of that. You start preparing them for the worst, you're going to lose a lot of deals.
I would
Yeah,
say
because there's also, I mean, these contracts have built in that the buyer's lender could go bankrupt, and what happens in those events. So you could do overload to somebody who's.
I want to keep it. Oh, this is so exciting! I can't believe you're buying this place.
so. I have a lot of checklists, and the checklists anticipate. And you say, get your insurance at this point. Blah blah blah. Do this at this point, and you give them a timeline of things to do, and the timeline of things to do is anticipation of all these things. So every time I have or learn of something that could go wrong, I've probably added something to the checklist. So each time you pass a certain point in the contract and your client says, now what? You say, okay, order your inspection, get your insurance, bind your insurance, don't just shop, this, that, the other. Because the thing is you're preparing them to do what needs to be done. And then when something happens, or they ask questions, you can say, here's why, and here's the scenario. But you're not going to give them every single hole in the ground that Wile E. Coyote is going to fall into, because, that just scares them. But if you have a checklist of here's what you do next, you're going to avoid a lot of problems.
Yeah, I think most buyers may buy 1 or 2 properties in their lifetime. So they likely have no concept of what even binding insurance means or the why aspect of it.
And that's why you have the verbal conversation. And then you follow up with an email, and here are your things to do. And then you put them on those tasks and you follow up with, did you do this? Please send me a copy of. And that way you're protecting them and you're protecting the closing.
Yeah, and our contracts so let's say like right now we have a hurricane or tropical storm in the grid and it's a named storm, and all insurances have now said that's it. As of today, we can't bind insurance until this thing dissipates. So our contract will say ultimately the day that occurs becomes day 0, and it's automatically suspended for a reasonable time up to 7 days. And usually the storms will blow through within that period of time, a couple days. And if we get hit on a Tuesday, Wednesday, it's gone by Friday. So you don't even need the full 7 days. But other events, active war or other triggering events. So our contract will talk about hurricanes, floods, earthquakes, fires, other acts of God, which I guess that could be disputed. Transportation delays, wars, insurrections, civil unrest like November 6th or whatever happens. Where's the laugh button? Okay.
Oh, December 6th. That's
November 6th.
November 6th too, right?
Yeah.
Oh, no,
Voting.
voting.
Yeah. So those kind of
I was
things.
thinking COVID. Is COVID active God? No, we're not going to talk about that right now.
COVID was deemed an act of God because it's not foreseen that a pandemic is going to occur, since they only come once in 100 years. But if it carries beyond a 30-day window of time, then effectively either party can go ahead and unilaterally cancel at that point. So it has a beginning and it has an end. Now, obviously, if buyer wants to buy and seller wants to sell, they could redo contracts. They could do whatever they want, but it provides for certain outs.
So let me
Our
throw out
list is shorter.
a scenario.
Mhm.
Buyer is under contract, insurance bound, to close the day before the hurricane is slated to land. Buyer goes, hey, I don't know that I want to close knowing that there's a hurricane that may hit tomorrow. but I'm under contract. Can I just want to wait until after it's all done.
I don't believe the contract allows for the buyer just to wait unilaterally. Now, if the title company who's doing the closing said, we're closed, we're not having anybody in, that is outside of the buyer's control. And now the buyer has a waiting option because it has triggered it.
Yeah.
So Destiny has a closing today. If the buyer got a little bit of cold feet, they could kind of stall in some sort of way, but they can't unless the title company.
Well, unless an event outside of the buyer's control has now created something inside of the force majeure clause, where now they can legally point to a line item in the contract that says, because of that reason, I'm entitled to do what I want to do.
Okay.
Yeah.
There's theory and there's reality. There's what the contract says and there's what the buyer's going to do. The buyer can just not sign and say, I'll face the consequences.
Correct.
And that's usually what happens. But in our contract, we have a cure period. So if somebody is breaching, for example, not signing the contract, the other side issues a cure notice. And this kind of fixes a lot of things. You have 3 days to correct the potential breach. And then if you haven't corrected that breach, then the side that's not in breach, the seller, for example, would say, okay, I'm going to force your hand. And that's where the contract is like, if you won't close, and the seller situation, all they can do is keep the earnest money.
So that sounds like basically you're always getting a 3-day extension.
Yes.
Yeah.
And that's why in our contract, you have to know it extremely well, because anytime there's a potential breach, in your fiduciary duty is to issue that cure notice. And a lot of agents view that as being mean. And I'm like, issue the cure notice, because if you don't issue the cure notice and then they do go into breach, 3 days have passed, now you have another 3 days or whatever.
Who's the one that actually issues the cure notice?
Agent?
Either the buyer or the seller. It's coming from them, but obviously you're the guide as the agent. The seller's not going to know the contract. The buyer's not going to know the contract. So as the agent, you say, hey, look, the buyer has not signed the we have to sign documents 3 days prior to, not including the close of escrow. So that gives us an opportunity. So if we're closing, tomorrow's the 25th, the buyer's doc should have been signed by end of business on the 21st. I would have issued a cure notice on the 21st. So they would be in breach tomorrow. And that puts the seller in a position of, I can keep their earnest money, I can sell it to someone else, I can do whatever. And typically people are going to abide by the contract if they think they're going to be on the losing end of the penalty.
So does Arizona have a standard fill in the blank cure notice that the buyer or seller fills out?
Yes. So it says buyers filling it out or sellers filling it out, and it has to do with this line in the contract. And then you can elaborate.
Okay, so let me do this. We're coming up on some time here. Let's just give an overall mark. There's a storm, an act of God, a something occurs. Let's just be aware that that's in the contract first and foremost, right?
Right.
And there are remedies within the contract, no matter where you're at, I would assume.
Likely.
And if you don't know what they are, you may want to take a class or read it or something to that effect, or reach out to your title company or closing attorney or whomever is doing that type of thing to get a sense of what that is. And when you're talking to clients, buyers and or sellers, advise them that this is a contract. You're not an attorney. You should contact an attorney, or at certainly the least, you, Mr. Buyer Seller, Mr. and Mrs. Buyer Seller, read the contract. I'll give you a general overview. If you have questions, please feel free to ask, but I'm not in a position to offer legal advice.
Yeah, and I think since that's such a pivotal thing, you probably should have a formatted email.
Don't we have something, Andrew, Mark, do you know this? Because if they don't get a home inspection or something, we require them to sign a document that says, hey, we said get a home inspection. You said no.
Yeah, because they'll never remember you having a conversation with them. But if it's filed up in an email format that says, we met, I gave you the following outlines, if you don't understand anything,
I don't think
call me or
like
something.
That, do we? You guys aware, Andrew, Mark, you aware we have anything
I'm not
like
aware
that?
of it, but I'm sure something like it exists. I don't know if we're using it.
Only related to the inspection release.
That might be a good idea for the whole thing to cover every dope, like this guy.
They still sue. They still get attorneys. They still
Yeah.
sue, but
But it's defensible.
I remember getting advice from an attorney one time, and I thought it was some of the best advice.
And then you divorce the guy?
Yeah. You have the contract that they're initialing and signing, but every time you have a conversation, John, you're going to remember this. You follow it up with an email and you say,
No way.
we discussed this item and your next step is, and my next step is, and here's what we're going to do.
That's professional.
And then afterwards, hey, how'd your son do in the soccer game? You ask a question at the end of the email that has nothing to do with the topic.
'Cause then they'll
that you're
respond.
reiterating, so that they respond. And that way you can send via, although people don't always like it, email that documents that it was received and opened. But if you have a response, then that demonstrates that they read it.
I always send one extra line that says, if any part of this is inaccurate or wrong in any way, please contact me immediately. And that way, because I've been in front of enough judges, they're usually just looking for a reason to rule in favor of one person or the other. So they would go, if that's what your argument is now, a year later, did you contact him immediately? And they're like, no, I didn't. Okay, well, then I kind of see where this is going. Stuff. It's not guaranteed, but at least it helps.
Okay. Anybody got any extra questions? Or I know we only superficially covered this. This is deep. We can go really deep. Mark might want to even do a class or something.
Next week, we'll do it in Italian. This week was French.
All right. Okay. Mark, you got anything? Simpson?
I don't.
All right. Destiny, you're new at this. Did you learn anything today?
I learned a lot. We're going to be closing tomorrow, so hopefully we will get this thing done and not be in breach.
Sweet.
All right. Andrew, you got anything?
Oh, we're good.
All right. Julie, tell us something new and special.
Follow up with an email, ask a question at the end so they respond.
Love that. All right, guys. Thank you for showing up. We'll see you all tomorrow, hopefully, right? And the next day and the next. See you later.
Bye, guys.
Bye-bye.
Bye-bye.